All right, when I started talking about this stuff at home to my wife, she thought this sounded kind of crazy at first, and I was happy to see that the first sighting of the 3 M&Ms included one nut. So we're going to bring it to the West Coast now for California and have Shelley Curran come up, the Director of Criminal Justice Services for the Judicial Council. She previously was a principal consultant with the President Pro Tem of California Senate and spent 7 years as a policy analyst with the Consumers Union. She has her bachelor's from Indiana University and a master's in policy analysis from University of Wisconsin-Madison. Did I get that all right? All right, can't read my writing. All right, thank you very much for coming down from San Francisco. Appreciate the drive. Welcome. This one's new, it's here.
Okay. Thank you very much for having me here today. I love coming down to Santa Barbara. It's always a treat. So what I'm going to do is I'm going to spend 45 minutes with you talking as much as I can about what's happening in terms of pretrial in California right now. I'm going to start out by talking about what we know in terms of who is in California jails. I think that really has become a driver in a lot of this discussion here right now. Spend some time talking about what the Chief Justice has recently announced, what's happening up in Sacramento, spend a couple of minutes on the legal framework, what happens in terms of regulation of the bail industry through the California Department of Insurance, and then flip over to some of the pretrial programs that are happening in California right now. You all are one of our Recidivism Reduction Fund planning grants, and so we have 11 grants that are actually up and running, funding full pretrial programs, and then a few planning grants. So that is my plan for the next 45 minutes. I would encourage people to ask me questions as we go along. If something comes up, don't be shy about doing that, please. So to start out with the jail population, right now in California jail, or I should say at the most recent data that we've got, which is the end of the quarter in 2015, end of the year in 2015, there were 74,000 people sitting in California jails at any time. Now I think it's important for people to think about the distinction. When we talk about ADP, that's the actual beds that are happening at any given moment. That's not the number of people who are cycling in. So at any point we've got, or at that point we had 74,000. Generally that's operating about 91% of jail capacity in California. I think our capacity is 80,000. 84% of the people who are sitting in California jails right now are somehow associated with a felony. So they are either serving a sentence for a felony, or they are awaiting trial on a felony, or they're a group of folks who have been rolled up for a probation violation, a parole hold, so on and so forth. One thing that I think it's really important to address head on right now in California is this whole question of unsentenced population. People throw 63%, 67%, and folks immediately conclude that 63% of people who are sitting in California jails right now are awaiting trial. And that's not the case, right? That population consists of anybody who is ineligible for release. And so that includes some people who are sitting there awaiting trial, but it's also our parole holds, our probation holds, our ICE holds. So that 63% is, I think as people have taken and run with it, but I think it's important to just address that out the gate and come forward with that. I also want to talk about another challenge that we've got in terms of data in California, and that is the phenomenal changes that have happened here just in the last 5 years, right? We started out with what at the time people thought was a big deal, which was SB 678, and in retrospect, that's kind of, not insignificant, but nothing in comparison to criminal justice realignment, and most recently, Proposition 47. So that those things have definitely changed what's happening in California in terms of our pretrial population. So I framed the looking at the data that we do have by these three general areas, and it really, it follows up on what Tim said, and it really looks at some of the things that the Chief Justice, who I work for, has raised. And the first is this impact on public safety, right? Are the right people sitting in California jails released or detained? The second is this question about failures to appear, right, as Tim addressed. And then the third thing And I don't talk about it as maximizing release as much as the way that the chief is thinking about it, and that's in terms of the impact on monetary bail and secured bail on low-income Californians, and wanting to make sure that decisions are not being made based on someone's pocketbook is the way that the chief has spoken about it. So in terms of public safety, right now there are 37 facilities in California that are under a federal jail cap in 19 different counties. So upshot of what that means is sheriffs are having to make some release decisions. Before realignment, we were at 12,000 people being released on any given month. Not realignment, Prop 47. Pre-Prop 47, we were at 12,000 people a month who were being released. Now we're about 10,000 people a month, which you think 10,000 people in the scheme of California is not an enormous amount. But if you look at it the other way, 10,000 people who, are supposed to be incarcerated for whatever reason are being released. And I think that this begs two really important questions. The first important question is, are the right people being released, right? Who are those 10,000 people that are being released? And the second important question, I think especially for the bench that we think about a lot, is what does that do for confidence in the justice system, right? So if you are a judge and you are sentencing someone and that person turns around and walks out the door 48 hours later because of a federal jail cap, what is that doing for confidence in the justice system? So I think that's just something that is important for all of us to be thinking about as we are making these decisions about, pretrial detention and the potential impact of pretrial detention on jail populations. So this, I hope you can't see it too carefully because this is brand new data, and this. So I don't want you to take the numbers to the bank. No, don't look more closely. I just said. But what I do want you to take to the bank is this question of who it is that is making bail, right? So on the lower end here, so the lighter bars at the end are kind of your lower level offenders, right? And it's very logical. It's very clear. Folks who have committed misdemeanors, whether they're kind of lower level misdemeanors or higher level misdemeanors, are getting out, cite and release, or they're getting out OR. When you get to the other end, when you're looking at your felons, especially that high felony level, you are getting out on bail for the people who are getting out. Now granted, two important caveats. Those guys who occupy that felony high level there are not getting out that often, right? A lot of those guys are detained for whatever reason. But 15% of them are getting out. And of the 15% who are getting out, about 80 of them are getting out on bail, which means 80% of the people who are being released over this, and this was a study, again, of data that's not final yet, that's coming out from a very reputable public policy research tank in California, and it's all going to be released soon. Their study over 49 months, looking at everybody who was booked into jail, about 1.7 million people. We did kind of quick and dirty, ugly math, and that number results in, our guess is, anywhere between 175 and 200 people on a monthly basis who have committed really serious crimes are getting out on bail. And we don't know whether or not those guys are being supervised or not. Now granted, Mimi's probably sitting there and thinking, wait a minute, what about risk assessment? I'm not saying anything about risk assessment, right? We don't know the risk level of these people. But what we do know is that they have been charged with very serious crimes. And we also know that people who have committed very serious crimes are the ones who are more likely, granted, not getting into risk, but they're the ones who are more likely to be committing more serious crimes down the road. So I think that's just something to be thinking about in the context of public safety when we're thinking about potential release. Next thing to think about in terms of the data is this question of failure to appear. Now, our failure to appear data is not great in California. Again, I feel like anytime I talk to people about data in California, you have to come in with all of these big apologies for a myriad of reasons, probably most significantly that we don't have any statewide system among any of our local justice system partners. But we do know a handful of things about FTA. We know that before Proposition 47, our multiple felony FTA rate, which is anybody who's had 2 or more failures to appear, is 6.6% in California. We also know that the felony failure to appear rate has remained relatively flat in California over the last 4 to 5 years. Now, I say relatively flat. We all know that the level of felonies has dropped significantly in California, but proportionately, so have the number of FTA warrants for felonies. That has been proportionate. Now, monetary bail is often associated with lower FTA rates than OR, but to my knowledge, and maybe Mimi or Tim know something different than me, no one has ever demonstrated that it's causal, right? So anecdotally, you think, that makes sense, but at least as far as we know, we have never seen anyone who has proven that. So how do we compare with the rest of the country? Not so great. So if you look at this, the darker shows who's being detained, and the lighter shows who's being released. We are detaining more people, and we still have more multiple FTAs than the rest of the country. So it just goes to show that something is not, we're not doing as great of a job as we can in California, at least in terms of what's happening in the rest of the country. And from what I understand, and at least some of these initial studies coming out, other places are using things like automatic callers. I went out to dinner last night. Our reservations were at 7:30, and at 5:45 I got a text. Hi, Shelley. We are looking forward to seeing you and your party of 6 at 7:30 tonight at this restaurant, and here is our address. And you think, boy, if a restaurant has to remind me of going out to dinner, and I have 2 little kids, and there's not much of a risk that I'm not going to show up to a dinner reservation when I have a babysitter. So if they're doing that, then maybe there's something that we could be doing in terms of working with people in the justice system for reminders, text reminders, phone call reminders, things like that. It's just one alternative that might help some of these numbers. The impact on low-income Californians. So this is something, as I said, that the chief has addressed a couple of times. Chief Justice spoke about it last year when she did the state of the judiciary, and she spoke about it again when she signed on to a statement with a handful of other chief justices throughout the country. And she most recently referenced this along with public safety, which is of utmost concern to our chief justice also. But she mentioned this when she spoke about all of those things. And when we think about the impact on low-income defendants, you think about it on the personal impact, right? And this makes sense. If someone is detained, they're going to lose their job. If they have children, it's going to be tough on the kids. It's, all of these other things. I saw someone speak about this last week, and he said, someone who's detained from jail, you come home, and your neighbor are not having a welcome home Shelley party when you arrive, right? There are some negative implications for having been detained. And then also the impact on the justice system, right? So Tim mentioned a couple of times some of the work from Marie Van Nodstrom, and she looked at huge databases from the state of Kentucky, and others have looked at it from other places too. And people who are detained pre-trial typically get longer jail sentences. They're more likely to plead guilty. They get longer prison sentences when they are sentenced to prison. So it also has potential impacts on the justice system also. And again, all of this is just something important to keep in mind. And as Tim talked about, all of these things are the 3 things that we ought to be thinking about. So one of the things that we have had a lot of conversations about at the council level, and also in our travels throughout the states, when we're meeting with different counties, is whether or not this is a real problem, right? I mean, are there really people who are locked up in California jail right now because they're too poor? Unfortunately, we don't have great data on that. The data that I have seen is from 3 different counties, and this is pretty recent. One is San Francisco, and that's from the pleadings from the Buffin case that I'll talk about in a couple of minutes. And they estimate about 10% of their unsentenced population don't fit into that category of an ICE hold, a parole hold, a probation hold, so on and so forth, and they're eligible. Another county that we saw from a civil grand jury, they were about 35%. And then a third county that I saw from direct sheriff data and talking to the sheriff was a little bit over 50% of their unsentenced population. In California, our unsentenced population, I think, is about 47,000 right now. So even if it's that low end of San Francisco, right, let's say it's just 10%, that's still 4,700 people who are potentially, now granted, there might be some people who say, I don't want to get out on bail. It is freezing. I drove down here this morning. I couldn't get over how cold it was. I would rather not. But nonetheless, I think the point is there are some people, right? We don't know the exact number. We're probably never going to know the exact number. No one is going to know the exact number. But probably there are people who are sitting in jails right now who are there primarily because they can't afford to get out. So the chief, as I mentioned before, set up this pretrial detention work group. And in doing so, she established it. She announced it at the October Judicial Council meeting. She asked 11 judges and 1 CEO to participate. The idea is to come up with a set of recommendations, and the recommendations can run from, you need more study, to I can't imagine that it would come to this, but it could be, I guess, you need a constitutional amendment, who knows, that will go to the chief by December of this year, that the chief will look at and then make some decisions about bringing them to the council. We had our first meeting last week, which is when Tim came and spoke with us. So we had Tim come and speak to the group. We also had a representative from the Pretrial Justice Institute. I think you've probably all seen some research that Pretrial Justice Institute has done. We had Dr. Ed Latessa, who's one of the main thinkers in terms of the use of risk and needs assessments in the country. And then we also had Jeff Clayton, who's from the American Bail Association. He came and addressed the committee. So we had a group of people with very different perspectives on the bail system and the whole concept of pretrial release to just begin that conversation with this set of judges. Our next set of meetings is going to be it's coming up in March. That also will be a 2-day meeting. At that meeting, we're going to have representatives from different states. So some of these states that Tim mentioned, hopefully we're going to bring them out to talk to the judges, talk about the experiences that they have had. Spend a couple, and we'll also have the Department of Insurance, the regulator of the bail industry, come and talk to us. Third meeting is going to be focused on local justice system partner input. We want to hear, what do sheriffs think about all of this stuff? What do district attorneys, what do public defenders, to give the members of the committee their perspective about what they want the committee to be thinking about when they are coming up with recommendations for the chief's consideration. And then also advocates, right? We want to hear from domestic violence advocates and Crime Victims United, all of these groups who represent victims in all of this, and then also people who are more pro bail reform generally to come and speak to the group to provide their input. Another group, and I think somebody mentioned this earlier, is the whole question of mental health in this pretrial discussion is immense. And so wanting to make sure that we have, county mental health behavioral people come and talk to the group about what they think and provide their perspective on all of it. So wait and see. It's going to be an immense amount of work, as you all can imagine, but that is moving along also. So as the chief is doing her work, and the judges who she has appointed are doing their work, there's also a significant amount of stuff that's happening in Sacramento right now. 2 bills have been introduced, SB 10 by Bob Hertzberg and AB 42 by Assemblymember Bonta, both introduced bail bills. They have, at least Hertzberg's bill was just amended last week to address misdemeanor bail, and from what we've heard from them, it's going to change. This is intent language: reduce the number of people detained pretrial, address racial and economic disparities, ensure that people aren't held in pretrial detention because of their inability to pay. We met with the sponsors, so the outside entities who are sponsoring the bill and helping the authors. A couple of months ago, they told us that there will be some element of preventative detention, there will be risk assessment, there will be preventative detention, deprioritizing monetary bail is how they put it. And so those bills are works in progress, but I think everyone knows, right? You turn on NPR or KCBS or whatever to get, for 20 minutes, an hour in the car, and you hear something about bail and pretrial detention. This is an issue that's huge in California and huge nationally. Folks are just talking about it right now. This is not new. I think it's much more, I think it's got a better shot, I guess, in terms of significant change right now because of the interest. But for the last 4 or 5 years, there have been efforts to look at the bail schedule. People love always to talk about a statewide uniform bail schedule. That comes up regularly. People have looked at pretrial release, more regulation of the bail industry, and diversion. Diversion, there was a provision in the budget trailer bill of last year called LEAD, Law Enforcement Assisted Diversion. It's based upon a Washington State program where law enforcement will bring someone who clearly has mental health or substance use problems to a service provider as opposed to getting them in the system initially, and so it will be interesting to see what unfolds with that. And then the other thing is this Recidivism Reduction Fund, and I'm going to talk a little bit more about that. But I think this just goes to show that we have been thinking about it a lot. Some things have happened in California, but I think the big stuff is going to be happening through these 2 bills, at least in terms of what the legislature is going to be doing. So I'm going to spend just a few minutes on this whole legal framework that we've got in California. Our main sources of law governing pretrial release and bail are the U.S. Constitution, the 8th, the 4th Amendments, the California Constitution, the Penal Code, and then we've got some case law in California too. Pretrial release, the Penal Code provides for 4 different options for release: bail, OR, under supervision. I say under supervision, it could be OR, under supervision, and then pretrial diversion. I'm not going to spend much time talking about pretrial diversion, but the other 3 I'm just going to review pretty briefly. Definition of bail. So it's in our Penal Code. It allows someone who's been arrested to be released from physical custody based on providing a cash deposit, bond, or other type of security to guarantee that the defendant will appear in court. The right to bail. We have a constitutional right to bail in California, except for someone who has been charged in a capital offense, and then there are some other judicial discretion provisions there for felony offenses with acts of violence, sexual assault, and great bodily harm. The bail, others are not entitled to release, and I mentioned this earlier, somebody who's got a parole hold, an immigration hold, or an extradition warrant. Bail can happen before first appearance by the sheriff or other jailer. You can accept bail in the amount set by the arrest warrant or the bail schedule. You release the arrested person who posts the bail or bond, and you set the time and the place for the person to appear at the appropriate court. Bail schedules in California are set by each individual superior court, as you know this. It lists that presumptive bail amount, and then different counties can add on amounts for enhancing or aggravating factors. This, as I mentioned earlier, is a hot topic often in California because they think, why in Alameda is something $50,000, but Santa Barbara has decided that's $5,000? What is the logic here? Well, a decision was made to allow each local court to make its own decision about how it is that they wanted to set bail and go with that. That's what the logic is. Setting bail. So the bail is set by the judge prior to or at the first appearance. It can't be set with the intent of punishing the defendant. Our Constitution prohibits excessive bail, but it's not considered excessive just because someone can't post it. I think an important point to raise. I want to mention Marsy's Law because that's something that was enacted by the voters in 2008. So pre-Marsy's Law, when judges were considering setting bail, they were looking at things like the seriousness of the charge, the prior criminal record, whether or not the person was going to show up at the court date. Post Marsy's Law, which was really focused on victims' rights, got to more the protection of the public, the safety of the victim, and the safety of the victim's family. So Marsy's Law is something that definitely needs to be talked about and thought about whenever anybody is thinking about potential bail changes in California. Bail and bail agents, you contract with the agent to post the bond for the full amount. Typically, agents charge about 10%, although I'm hearing more changes in that, charging less amounts, having people pay more later, not at the beginning. So they're changing some of their practices. And then you can secure the bonds with collateral from the defendant itself, family, or friends. So OR is the next type of relief I'm going to talk about. It's discretionary for the courts. In a nutshell, the person promises to appear at all of their court hearings. They're not going to leave the state without permission. They're going to obey all reasonable conditions imposed by the courts. The courts can impose reasonable conditions. It's things like electronic monitoring, alcohol monitoring, release to home detention, things like that. So there is some discretion that courts have too in terms of how it is that they supervise or they set conditions. California Department of Insurance. So they are the regulators of the bail industry. So right now, operating in California, there are 17 sureties. Those are the big, some are very, very big insurance companies. 155 bail agents, 3,240 bail agencies, 3,240 agents, permittees, and solicitors. I think notably, there's no regulation of bounty hunters, right? So Dog the Bounty Hunter, and these guys, they are not regulated, but the California Department of Insurance does take complaints about bounty hunters and will look into those complaints, but they don't regulate them in the way that people think of traditional regulation. CDI did an examination of bail in 2013. There were 176,000 bonds written. I'm dropping all of my stuff, excuse me. I am going to need those. The face value was over $4 billion. The premium collected was over $326 million. So the premiums that went to the sureties was over $27 million. So retained by the bail agents was over $299 million in California. And we don't know what the forfeiture amount is. That's something that often comes up. Well, how much did they lose? So I think the point of this slide is to show you all that you're in the wrong business. Oh, yeah, that's 1 year. So I'm not going to talk about any of these cases. I just want to point them out to show, and Tim mentioned this earlier, this Equal Justice Under the Law has filed a bunch of lawsuits throughout the country. And at first it was, small southern towns that you think, boy, they're locking people up for not being able to pay a traffic ticket, so on and so forth. But that changed when you mentioned Harris County, Texas, and then they've come to San Francisco. They've made their way to California. So they have sued in San Francisco and they have sued in Sacramento. San Francisco's is about 14, 15 months old now, and it's almost the anniversary of the Sacramento case. So Buffin in San Francisco and Welchen in Sacramento. Both allege civil rights actions, equal protection, and due process. And in a nutshell, the plaintiffs in both cases assert that the current California bail system, as applied in San Francisco and Sacramento, impermissibly ties pretrial freedom with wealth status. Where we are right now, I think this is, I'm pointing this out because I think it's pretty significant. In the Buffin case, originally, at one point we thought the court was going to be named. They're not. But the AG and the sheriff have been named. The sheriff declined to defend the bail system. This is the San Francisco sheriff, declined to defend the bail system. And in December, then Attorney General Harris indicated that she would re-intervene, and then she changed her mind, so she is not intervening. So I have not heard any status about what our brand new, literally, I think 48-hour new Attorney General is going to do, but at least as of now, the California Bail Agents Association is trying to intervene, and that hearing is going to be in February. Sacramento is pretty similar. What happened in January, the AG defended only the facial constitutionality of the bail system. So she said, Maybe it's legal on its face. I can't say anything to how it is that it's being used in California, how it's being applied in California. And the sheriff came out and argued that they shouldn't be the ones who are named in this, but it should be the state and the superior courts. And as of today, at least, we haven't heard the status of those. I highlight this and bring them up just to show that there is not resounding defense of the bail system in California, at least of now. Now, I think that will change if the bail industry, becomes party to the suit and they are able to defend it. Then I think that will change. But at least as of now, at least the elected officials in California who are impacted by this aren't really giving it their all, I wouldn't say. So the plaintiffs, Ms. Buffin is, and I highlight this because they got pretty good plaintiffs here. So Ms. Buffin, grand theft of personal property, detained bail for $30,000. She works at the Oakland airport. She supports her mom and her 2 younger brothers. Ms. Patterson, similar, detained on $150,000 bail. And Mr. Welchen, this was the first, he's on disability. That's his Social Security disability, his only form of income, and this was his first arrest. So these are the plaintiffs that they've got. So now I'm going to shift gears and talk a bit about the Recidivism Reduction Fund. And these are these grant programs. This came about as part of the budget in the Budget Act in 2014. There was an agreement between the legislature and the governor to set aside $105 million to do things to reduce recidivism. It was really general like that. The courts at the time received $15 million, and then subsequent to that received $1.7 million. For 2 purposes. One was for collaborative courts to establish or to maintain existing collaborative courts, or to begin pretrial programs in California. So $5.23 million went to 11 superior courts for pretrial programs. The program, unfortunately, the funding is just about, our time is wrapping up, and the program is going to end in April of this year, but the council was able to award 11 different grants. Kind of in a nutshell, the important things about these programs is that they're court-led. It has to be in partnership with local justice system. Risk assessments needed to be a part of it, and there needed to be a report and evaluation component in the program as well. We found, and we were later given money for, in order to help courts do some planning around pretrial programs, and as I mentioned earlier, Santa Barbara was one of them, and so $45,000 went to 3 different courts for planning. And this is just where the courts are. The dark blue are the actual courts that are up and running. And then the yellow, I did that specially. I should have just, made Santa Barbara orange to show you guys where you are. Those are the planning grants that we have throughout the state. So we will have more information and more data on those programs in the coming months. But at least initially, we did a quick survey just a few weeks ago in preparation for our first pretrial detention work group. And I just wanted to highlight some of the things that we found just in our initial survey. The Superior Court and probation are pretty close in terms of who the lead administrator is for the pretrial programs. And this was a survey of those 11 courts plus about 6 others. So it was a survey of 17 California justice system groups. Sheriff plays a decent role in some of it. 16% sheriffs are covering. Agency involved, the court, again, as they're supposed to, because it's part of the Recidivism Reduction Program, probations, DAs, public defenders, sheriff, health and human services, private criminal bar, Department of Correction, community partners. That shouldn't come as any surprise, right? Everybody is, or for the most part, people are keeping, having solid teams come to the table. In terms of the tools, it sounded like you guys are going to do, you're going to go with the Virginia tool, and that is you're in good company because about 1/3 of the other counties that we surveyed are also doing the Virginia tool. ORAS, this Ohio tool, 37% are using that, and then we do have a couple of courts in California who are doing that PSA. Santa Cruz and San Francisco are both PSA courts that I'm aware of. There may be others, but those 2 are doing that Arnold tool that folks have been talking about. It's interesting, the whole concept of the use of risk assessment tools in pretrial. It's, you know, a few years ago, it felt like we were all focused on risk and needs assessment and community supervision, and I think that's really where people became more familiar with this whole concept of risk in criminal justice systems, this use. But now pretrial has just absolutely exploded, and it's incredible to think about. You know, some of these tools are 8 and 9 questions. You're not interviewing someone, you're just clipping through these things and making these decisions. So it's pretty interesting. And I know that Ohio's tool, they went through and created, you know, kind of your traditional risk and needs, which is a much more robust tool. And then they went through and just, you know, came up with a handful of other tools right on its heels. So the probation, in the vast majority of the time, probation are the ones who are actually administering the risk assessment tool. Sheriffs are also, and then we've got couple courts actually who are doing it with court staff, and then the Pretrial Services Agency. But again, and it's same with risk and needs assessment for probation. They have a lot of experience with that, and so I think a lot of courts naturally, or a lot of counties, excuse me, naturally are going to probation departments to do that. We do have excluded defendant case types, and this is always a really interesting conversation, and I think this gets to kind of the heart of how comfortable a different community is with applying this new practice to different types. And so quite a few counties just out and out excluded your violent and your serious and your strike offenders, and then it goes down the list, right? So, some people single out sex offenses, domestic violence, warrants, holds, DUIs. So what sort of information is provided to the officer, to the judicial officer? The risk assessment score, criminal history, housing, all of these other factors are things that are actually getting before a lot of these courts when they are making these decisions. When they receive it, I think is also something important. We came up with the slide, and I didn't bring it with me. I could share it with Daryl if you would like. But of the different places where bail comes into the decision in the process, and it's pretty nice for us at least to have had that visual to see the different places. So it's also interesting here to look and see when it is that the judicial officers are getting this information as they're making these decisions. I don't know if you guys have talked about it, but one of the research findings that Marie Van Nodstrom also has is the impact of people. The longer that they spend time pre-trial locked up, the more likely they are to be arrested down the road, and even 2 years out. So anything after about 48 hours, you're kind of getting on the edge there in terms of potential, increasing the likelihood of potential future criminal behavior. And it makes sense logically, right? I mean, you think if somebody is removed from their community and removed from their home and removed from their job, then it shuts some doors that otherwise wouldn't be short. But then that begs the magical question in California, and that is, how the heck can we process these people any more quickly, right? It would take district attorneys charging really, really quickly. It would take judges. And so it's that I think is an important conundrum that needs to be looked at, I think, on a policy level of how to address some of those issues if they want to. Types of supervisions, check-in. To mention, I guess we apparently consider check-ins also as supervision, where we come from too. So check-ins, everybody's doing check-ins, drug testing, court date reminders, monitoring. And this is the last slide that I've got, and that is looking at overcapacity and jail release, and which counties are actually in a position where they're having to do overcapacity and jail release, and it's a significant amount. So with that, I think I have, just about run my time, but I do have a couple more minutes left for questions if anybody's got them for me. Sure.
Do you know which jurisdiction DUIs from their?
I don't know off the top of my head. I could find out though for you and let the court know. Yeah, that's no DUI. It's interesting. When we were at talking about it at the pretrial detention work group, DUI and domestic violence were two of the things that continue to come up as real deep concerns that need to be that need to be addressed.
Maybe I'm the only one that doesn't understand this. What does it mean that?
Yeah, I can see.
Yep. It means that the local justice system partners have decided that they're not going to bother doing, or they've decided to not do a risk assessment on those particular charges. And so for some, you'll see it's, you know, the more serious crimes. I think we're not doing risk assessments on sex offenders because we have our policy in place for sex offenders, and no way are these guys getting out. But then misdemeanors was the other end of the spectrum, and those guys think we're not doing misdemeanors because they're going to get out anyway, because our jail can't house misdemeanors right now, and so why take the time to do the risk assessment on the misdemeanors? We don't have the staff capacity to do all of these, and so targeting it because of resources.
So it sounds to me that in a risk-informed system, that's counterintuitive.
Yes.
Okay, thank you. Just checking.
Was that a trick question?
Just want to make sure I was following.
Yes. Any other questions for me? Okay, thank you.